Okay, so when a landlord wants to evict a tenant, there's a certain procedure that they must go through. Your landlord, in almost all circumstances, can't just verbally say to you they want you to leave, or they can't just write you a letter. What they'll have to do first is send you a notice, and this notice will have to be in a specific form, so it will have to contain specific information. What information that is will depend on what kind of tenancy you have and why they're trying to evict you, but it will almost always say notice to quit or notice seeking possession at the top. And if they're trying to evict you because they're accusing you of having done something wrong, for example not paying your rent or causing a nuisance to your neighbours, then it will tell you that, but in all cases it will tell you when they would like you to leave, when the notice expires. Now, if you don't leave by that date, then the next step is that the landlord will have to start a claim off in court and ask a judge for a possession order. So you will receive from the court and from your landlord a claim form, which will be setting out the details of their claim, and it will ask you to put in a defence within 14 days. If you're a social tenant, or if you're any kind of tenant and your landlord is wanting to evict you because you're accused of doing something wrong, then if you put in a defence a little bit later than 14 days, there won't be any consequences apart from in your legal costs if you win the case. However, if you have a private landlord, or in some cases a housing association landlord, and the kind of claim that they're doing is a Section 21 claim, just because at the end of the fixed term they would like you to leave, then you must put in a defence if you want to defend the claim within the time, otherwise you're at serious risk of not getting a hearing and a possession order will just be made against you, and that will be that. In all other cases a hearing will be fixed anyway, so you can get legal representation if you want to defend the claim, or if you don't manage to get legal representation, if you just go along to court, in many cases a duty solicitor will be there to help you. If you do want to defend the claim and you're planning to see the duty solicitor, then make sure you bring all relevant documents with you. For example, if you haven't paid your rent for a specific reason, then bring evidence. You know, you're going to need to show a judge why. It's not enough to just necessarily come up on the day and say why. So at this hearing, it will be very short, usually about 5 minutes, and a few different things could happen. The first thing is that your landlord's claim will be completely dismissed if you can prove then and there that you have an excellent defence, or just that your landlord's done something wrong. The second thing that might happen is that it might be adjourned, so that you'll have another hearing at a later date, or there may be some directions given if it's seen that you have a defence but it's a bit more complicated and you should definitely get a solicitor in those circumstances. Or the last thing that might happen is that a possession order is made against you. If a possession order is made, again you'll be given another deadline, which is that you will have to leave the property, usually within 14 days, or if you can prove exceptional hardship, within 28 days. Again, if you don't leave the property by that deadline, then your landlord will have to apply to court again to get a warrant to evict you, and that's when bailiffs will come to evict you. You won't get another hearing before bailiffs come unless you apply to the court to set the warrant aside or to stay the warrant. What you'll get is just a notice of eviction from the court, and it will give you a date when bailiffs will come. And this date in some ways is the real date when you have to leave, because if you don't leave by this date then and you don't succeed in applying to get this set aside, then you will be evicted by bailiffs coming to your home. It may seem from this that why on earth would you leave sooner, because you can just stay till the very, very end, but there are some disadvantages in waiting for the bailiffs to come. If you wait for your landlords to have to issue a claim in court, then if a possession order is made, then you will have to pay their legal costs. If you don't put in a defence, then these will be limited to a few £100s, but if you do defend the claim and put in a defence, then you may have to pay your landlords full legal costs for all the work that they or their solicitor does, which could be quite substantial. But it may be that you aren't able to leave, or that you think you have a good defence, and if you don't leave until the day that you're evicted, your landlord still has all the obligations that a landlord has up until the day that you're evicted, and you have all the same obligations as the tenant, for example, to pay your rent up until that date. So if you've received a notice or if you've received a hearing date from the court and you're worried about this or any issues to do with being evicted, then do call Anthony Gold and we'll see whether we can help.